Final case on the docket this morning, Watson Real Estate Development Incorporated versus Tammy Cessna and others, 129936, an appeal coming out of Shawnee County. I would ask council to please enter their appearances.
May it please the court, appellants appear through David Watson and Elizabeth Baker, who also appears on the brief.
All right, thank you.
May it please the court for Tammy Benfield Cessna, Sam Allison Natali of Kansas Holistic Defense, and Casey Johnson of Kansas Legal Services.
Thank you. And let's see, appellant, do you wish to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes, please.
5?
5.
Thank you. Proceed, counsel.
Thank you, Your Honor. As the court is aware, this matter comes up from a limited actions appeal. It was a limited action civil case. In that case, there was a subpoena issued on a witness compelling the witness's attendance at trial.
Which was you?
Which was me, yes, Your Honor. It makes for an interesting write when you write the brief and talk about yourself in the third person. The brief sets out what I believe are the two issues raised in the case. One, did the trial court correctly interpret KSA 6245? And two, what is the scope of authority that a court has over an attorney practicing law? And whether the scope of that authority allows the court to order the lawyer to act as a witness in a case without compensation that is guaranteed under KSA 6245. I'm certain the court is aware of the arguments and the issues raised. And I think Judge Hill said it best when he goes, "It's your argument, counsel." And so I was thinking about this case this morning, and it struck me that, what's the importance of the case?
Well, let me ask you this question.
Yes, Judge.
Where do you live?
I live in Florida.
Where's your bar address?
My bar address is Florida. My bar practice, I have an office in Topeka.
So you're saying you have so where do you live when you're in Topeka?
Well, lately I've been staying with my fiance, which is in Topeka, Judge.
Okay, and how often are you in Topeka?
Maybe half the time, 50%.
All right, and wasn't the date of this trial picked by you?
That's an interesting argument. Yes, it was picked by me, Your Honor. But it wasn't because I intended to be trial counsel. I never intended to be trial counsel. Trial counsel was always intended to be Miss Baker. So the act of picking a trial setting was to ensure that the trial didn't conflict with her calendar, not mine, Judge.
But you were the attorney of record at the time the trial date was picked. Is
We were both attorneys of record at that time, Your Honor.
But you were the attorney of record.
Yes, correct, Your Honor.
All right.
And you had been historically appearing at each hearing, correct?
Incorrect, Your Honor. I've been appearing at some of the pretrial motions. Miss Baker had appeared at every hearing up till about May of 2025, I believe it was, at which she asked for some more mentorship because things were getting strange in the case. The pretrial motions, some of the discovery issues or lack of discovery issues, the fact that there were going to be arguments over jury trial instructions. All of that she had never done before, so she asked if I would assist. I said I would. And so I started appearing in May. I think it might not even been May. It might have been July when I first appeared in the case. Because I don't recall being present at a couple of those earlier hearings. But when I go back to the importance of the case, I'm reminded, it's important to me as a litigant, clearly. You guys identified, I am the witness. I am here. This is very important to me. Judge Lewis, when I worked for him, once told me, cases are important to the litigants that come before our court. So they will get due consideration, no matter if it involves $5 or it involves $1 million. So that's one issue that I believe, what's the importance of the case? But it's bigger than that. KSA 6245 is applicable in all Chapter 60 cases. It's applicable in Chapter 59 cases. It's applicable in Chapter 61 cases. That particular statute governs the subpoena of a witness.
Is that statute, when you read it on its face, discretionary?
I don't believe so, Your Honor. I think the parts of it are. The requirement that a fee accompany the subpoena, the appellants would submit as mandatory, not directory. So I believe it's subsection B that deals with service provides that service of a subpoena may be made anywhere within the state, must be, of course, in accordance with 6203. If the subpoena requires a person's attendance, it must be accompanied by fees for 1 day's attendance and the mileage. So the court's faced with, well, what does must mean? The trial court was faced with, what does must mean?
I always thought I knew what must was when I went to law school, but I don't now.
Well,
So, so the question I have, they gave you a filing fee plus mileage.
correct, Your Honor.
And was that mileage from your office to the courthouse?
It was $12, Judge. $10 is the attendance fee. $2 under the current mileage will get you 2 miles. And my office is, I think, 10 miles from there was no calculation in it. Miss Burge, who was also subpoenaed by the appellees in this case, got 0. Now, she's not an attorney. She doesn't have the resources that she can challenge the sufficiency of the fee. But it was 0. I mean, she didn't even get the fee. Arguably, the subpoena wasn't even valid. And so the trial court took that issue and addressed it in.
Were you served in Florida or in Kansas?
I was served in Kansas, Your Honor. I was served at a hearing in Kansas.
Okay.
And were
I
you
think-
not the officer of the business entity when you were served?
Yes, Judge. I'm the
mean-
CEO of the company.
Okay.
I don't dispute the judge's ruling that we can't bring Mr. Watson back from Florida. We can. I mean, the statute seems pretty clear. The applicability of when the court must quash a subpoena excuses that requirement of an out-of-state witness if they're a litigant or if they're a officer of the company.
So I don't recall, did you try the case or
I did not try the case, Your Honor.
that you was called as a witness?
I was called as a witness. Your Honor said, always thought must, I knew what must meant. I like telling Judge Lewis stories. I really appreciated him. I thought he was one of my mentors. He wrote a dissent in an opinion that when he was sitting on the Supreme Court, and I cite it in my briefs where he says he always thought it meant what the common language thought it meant. And I remember him telling me, well, I got it wrong because the Supreme Court told me I was wrong, and he's in the dissent.
Well, can I ask you a jurisdiction question?
Yes, Judge.
You filed this appeal as Watson Incorporated.
I filed it both. I filed it in my individual capacity and as the plaintiff in the case.
Okay.
And I appear on the docketing statement in my individual capacity. And I'm here today in both my individual capacity and representative of my corporation.
All right.
Because I couldn't figure out the jurisdiction. I was trying hard to figure out what the appropriate jurisdictional venue was to bring it. I mean, it's an issue you guys have never seen, I don't think. I spent a lot of time researching it, and I can't find where this court has ever addressed the applicability of service of a subpoena and the requirement of the fee. The appellants would submit that's equally important, in my opinion, as to the scope of the court's authority over a practicing attorney. Because I accept that there is that authority. I mean, we all get regulated. Lawyers are regulated under code of ethics. Judges are regulated under the judicial canons. But where does that play into requiring a witness to appear and testify as a witness?
It seems to me that the application of the witness is irrelevant to whether you're an attorney or not. If you're a witness, you're a witness, and that statute doesn't speak to if you're an attorney and a witness.
Correct. And we make that argument, I believe, in our briefs. It's not limited to just non-attorneys. You'd be creating class.
Everybody that's a witness.
It's a witness. If you're a witness, that's where the trial court's power is derived. The trial court's power to compel somebody to testify is derived from 6245, unless, and I just discovered this morning, should have looked earlier, it's a good argument, but KSA 223214, subparagraph 3, is the criminal code. And the criminal code Subsection 3 specifically says it shall not be necessary to tender any fee or mileage allowance to any witness when he is served. The legislature recognizes the difference. In the criminal context, we want to protect the criminal defendant. So the state ends up picking up the cost of the witness. In the civil arena, it's the litigant's responsibility to ensure that their witnesses are properly compensated.
Any other questions? All right, thank you, counsel.
Thank you.
You still have your rebuttal.
May it please the court, on behalf of Tammy and Benson Cessna, Sam, Allison, Natale of Kansas Holistic Defenders. This is not an appeal about whether or not Mr. Watson and his company made a false claim to collect a debt that was not owed by his tenants. Nor is it an appeal about whether or not he wrongfully withheld the security deposit of his tenants. A jury has decided those things, and those issues are not in dispute in this appeal. This is not an attack on the judgment. What is at stake, Your Honor, is whether or not Mr. Watson's victims will get that money that they have so long deserved, or whether or not in another unlawful claim it will disappear back into Mr. Watson's pocket. Because
I don't understand your argument. There's a pending judgment that he's not appealed.
that's correct, Your
The
Honor.
only thing is, and it's accumulating interest because he posted a bond.
That is correct. But if he gets his way, then he would be able to extract that $1,895 that he now claims is due to him in a witness
Oh, you're
fee.
talking about he wants an offset.
I mean, there is nothing else that's being asked for in this appeal by Mr. Watson except that he be paid in his personal capacity $1,895 that he says are due to him as a witness.
And did he raise his request for a witness fee before the district court?
Not quite, Your Honor. He raised a motion to quash the subpoena. And in that motion to quash, he said, either I want to be paid or I want it to be quashed. And the district court decided, and the standard review of the district court decision is abuse of discretion, that he was not entitled to bring a motion to quash because he is a party officer and because this was not an undue hardship, which would allow him to have a motion to quash. After that motion to quash, nothing else happened with the subpoena. There was, he was never called as a witness. He never testified. He was never compelled to testify. Nothing is in the record that indicates at all that that anything else happened with the subpoena.
Did he appear?
That's not in the record, Your Honor. And frankly, it wasn't clear being there at trial. Again, if you think that it's important whether or not he appeared, then you should dismiss the appeal because he did not include any transcripts from the trial, which would tell us whether or not he appeared. But he was never called as a witness. He never took the stand.
So if he was he not paid a witness fee?
He was paid $12, which the court found was sufficient mileage. So he was paid, and nothing else happened. There was no enforcement mechanism. And that's the main issue from the threshold issue of whether this is properly preserved for appeal. Ryan and this court's case, Kansas case law, especially Kansas Med Mutual Insurance Company versus Fati, all indicate that a party who wishes to preserve or have some review of a denial of a motion to quash must either comply with it and therefore shoulder its burdens, or not comply with it and then may appeal the contempt citations or sanctions that are then imposed. And this is a rule that is so well cited that it appears in the Appellate Practice Handbook. And it cites specifically to a case, Reed versus Hess. And in Reed versus Hess, this is not an interlocutory appeal. So interlocutory appeals are governed by the collateral order doctrine, typically for non-parties, right?
But for a party to the case, one still has to oppose and be held in contempt or otherwise sanctioned, and then, as happened in the Reed case, may appeal those sanctions as part of a appeal on the judgment of the case. That's the proper way to bring this. And the reason for this is laid out by the various circuit courts. It's to discourage meritless relitigations of every discovery order that happens below. But it's also a way of forcing there to be a record. So in some cases, if the person says, I'm not going to come, and then they're never called as a witness, well, there's no hardship, there's no issue, there's nothing to appeal. On the other hand, if they do, and they are brought forward on a proceeding in contempt, then a judge may say, pursuant to the language specifically carved out under 6245 subsection subsection E, the issuing court may hold in contempt a person who, having been served, fails without adequate excuse to obey the subpoena. At the point of the contempt citation, Mr. Washington could say, I have adequate excuse to disobey the subpoena. It would be a hardship. The fee was not paid. And there would be evidence, actually, an evidentiary hearing on those issues. And so there would, in fact, be a record of the many things that Mr. Watson points to in this very argument that simply do not appear in the record at all. There is nothing in the record of him appearing. There is nothing in the record of him being forced to comply with the subpoena, nor is there any litigation after the fact in front of the trial court saying, after the trial happened, saying, hey, I still want, even though I did not testify or was not called, the retroactive payment of this witness fee after all. That also wasn't raised below. And so the rule articulated...
The issue about the inadequacy of the fee was never litigated before the district court.
That's right. It was only litigated in the context of a motion to quash, and the court found that a motion to quash was not available to Mr. Watson because a motion to quash is only available for the types of individuals that are listed under the statute, that being non-parties.
Is a denial of a motion to quash appealable?
A denial of a motion to quash is generally not appealable. Under the rule laid out in Svati, Ryan, and Reed.
It truly is collateral.
It's truly collateral, unless, of course, there are sanctions that are imposed.
It's certainly not a final order.
Precisely, Your Honor. And just because the case resolved does not make that a final order. The case resolved, but that order still never became final. And it is precisely to discourage the situation that we find ourselves in, where a party can lose on a motion to quash, have nothing else happen with that subpoena whatsoever, never raise the issue again, and then it comes up for the first time, really, on appeal here. And so the court doesn't even need to address the merits here because, first, it was not properly preserved for appeal. Secondly, insofar as there are things that Mr. Watson is saying, Mr. Watson said that he was called as a witness. That is not in the record. That is not true. And insofar as that would be important to this court to decide the issue, then it would have been the appellant's burden to produce those transcripts.
Do we even have jurisdiction of this case if Mr. Watson was not a party to the action other than as an officer of the corporation?
I believe you would not, Your Honor. The issue here is that, and Mr. Watson vacillates between referring to himself as a non-party or a party officer or the attorney insofar as there are benefits under one or the other of those. But in this case, the appellant here is the plaintiff, which is his company, which is not Mr. Watson. And insofar as the order would have become final to Mr. Watson, that only would have happened had there been some sort of enforcement of the subpoena, some sort of contempt to him. So it is deeply unclear which Mr. Watson appears before the court or brings the appeal, but I agree that there is a fundamental standing issue here that is not adequately addressed within the briefings. And this becomes all the more absurd because even if the court had ordered witness fees to be paid, then those would have become recoverable by the defendants because the defendants were the prevailing party. So even if the court had awarded Mr. Watson the fees, one, there is nothing to say that the defendants would have paid that, right? If the court had said, oh, well, you have to pay this or I'll quash the subpoena, it could have been that the subpoena simply got quashed. Or if they had paid it, even if this were remanded back, then any mileage fee owed to Mr. Watson would be recoverable as costs because, again, the defendants are the prevailing party. The defendants won a verdict at trial showing that their security deposit was wrongfully withheld by Mr. Watson's company.
So if Mr. Watson's entitled to the $1,895, he gets it paid and then he turns around and pays it right back to your client as costs.
Precisely.
So he still owes the judgment plus the costs.
That appears how it would play out, Your Honor. Which is why this is a meritless and ultimately frivolous appeal that boggles the mind as to why we are here over an $1,800 judgment.
Did the court assess costs at the trial?
No, Your Honor, neither party, we did not raise costs at trial because ultimately there was a transcript that was ordered and the $12 mileage fee to Mr. Watson.
Well, the transcript would have been ordered after the fact.
Certainly.
And the filing fee would have been paid by Mr. Watson's corporation.
Precisely. Well, yes, exactly. And so neither party brought costs. It was not litigated below. And so we don't, again, this is why this issue isn't properly preserved for appeal because it forces us to say, okay, what would have happened had this gone Mr. Watson's way? Is there ultimately any way in which Mr. Watson would get the relief that he's seeking? And the answer is plainly no. Furthermore, I do want to turn just a little bit to the merits arguments, Your Honors. The motion to quash is reviewed for an abuse of discretion standard. And so the question, even if the court wanted to address the merits here, is whether the court's decision was an abuse of discretion. And the answer is it was plainly not. The court decided the issue on a few grounds. First, the court decided that a motion to quash was not a proper vehicle for a party officer contesting the 100-mile limitation. That's clearly barred in the statute. Then the court addressed whether it could be quashed under a theory that it's an undue hardship, and the court made a factual finding that it would not be an undue hardship for Mr. Watson. And finally, in the alternative, the court reasoned that Mr. Watson could nonetheless be ordered to appear as an attorney on the case. And it's important to recognize two facts. That the defendants brought a motion to disqualify Mr. Watson, saying that he was likely to be a witness in the case. And Mr. Watson chose to fight that motion and stay on, or have the right to stay on, as counsel. And then he was treated as the court as counsel. That is ultimately invited error. But I want to direct the court to the record at volume 8, 50 to 51. Mr. Watson picked this court date. He said, the court had suggested the week of the 6th of October. Mr. Watson said, I'm going to be out of town on the East Coast. Can we do it the next week? And the court granted that court date. If I say, I'm going to be on the East Coast this week, can we do it next week? There's a very strong implication there that I won't be on the East Coast next week. It is at at a minimum, very close to violating that duty of candor to then say, actually, when I said that I was going to be on the week of the 6th, could we do it on the 13th? I was actually also going to be out that week of the 13th. And this was only raised by Mr. Watson after he was issued the subpoena. The first time that he tells the court, actually, I'm not even going to be here on this court date, was when he was issued in court at a hearing a subpoena. And this type of gamesmanship is characteristic of this appeal and why it is so improperly brought. And if Mr. Watson wants to talk about the importance is that his tenants deserve their security deposit back. They took this all the way through a jury trial to get it, and the jury awarded them that security deposit back. And it is only for the purpose of delaying that justice or denying that justice that Mr. Watson's appeal is
What was
brought.
the amount of the security deposit?
The amount of the security deposit, Your Honor, was $1,700. Was the amount of the security deposit. Your Honor, may I briefly answer?
I asked the question.
The amount was $1,700, and we had asked for also an award of statutory damages in the amount of 1.5 times on top of that. The jury did not have a special verdict form to decide how they got to $1,700, but that was the amount that they were seeking.
Denied your statutory fees.
Or it could have been that they agreed with the statutory fees but offset them with some amount of damage that had been properly assessed, but found that the rest of it had not been properly assessed because Mr. Watson ultimately brought a claim for over $5,000 in damages, all of which was not awarded to the plaintiff.
Counsel, your time's expired.
Thank you.
Your rebuttal?
Thank you, Your Honors. Security deposit was about $2,600. I'd have to go look to get the exact number, but it was composed of both 1 month's rent and a pet deposit. So they were suing for the recovery of somewhere around $2,600, might have been $2,400, Judge. The plaintiff had claimed damages of around $5,000. So it was a general verdict form. Jury heard the evidence. Jury awarded about $1,700. A bond has been posted with interest.
So tell me fundamentally, you're the appellant. Why didn't you include the transcripts in the record on appeal that reflected your agreement for the trial date?
Honestly, I didn't think it was necessary. I think it's the party's responsibility under our rules to provide the court with the record that it feels is necessary to make its decision. In this case, this is a weird case. You talk about candor. How about telling the court in pleadings after you're made aware when I purchased my travel plans and my plane tickets that I had lied to the court and that I had actually only bought the ticket after the hearing in which I was served? That was a lack of candor, and it wasn't made by me.
But you agreed to the trial date. So how
I
would that,
did.
so how would that affect your purchase of a ticket?
No, I'd already bought the ticket. I was never going to be trial counsel. And
I'm having a problem with this because you're appearing as counsel and you're agreeing to a trial date, and now you're telling me you're not trial counsel.
I was never going to be trial counsel. I was never going to be trial counsel. I think we did cite in our reply to some of the places in the record where the court was aware of that. He even comments on it. I think he said something like, I knew Mr. Watson was going to be in Fort Lauderdale. When you try a case and you've got multiple counsel, you don't just hold up a sign and say, here's trial counsel. It's trial strategy. It would actually be unethical to disclose your trial strategy. When you're in court at a pretrial conference trying to decide what dates work, counsels both have their calendars open. Counsels are both looking at their calendars to make sure what is available, what isn't available, to make sure we can meet the demands of the court. There's nothing magic about it. I wasn't representing. In the August hearing, I had no clue I was going to be a witness other than the fact that I was identified on the plaintiff's list as a possible. I'm not actually the best one. My son runs the leasing operation. He would have been the perfect witness, and he was identified on the plaintiff. It was when the game of saying, let's try to disqualify Mr. Watson as the attorney came up. The hearing we had wasn't disqualify Mr. Watson as trial counsel. It was a motion to disqualify Mr. Watson as the attorney. The rules don't require that. The rules require that if I am a witness, I cannot be trial counsel. Well, they solved that problem at the end of that hearings when they served me with a subpoena and said, haha, you're now a witness. To answer your question, Judge Hill, to give candor to the tribunal, I appeared. I'm an officer of the court. I will represent. I appeared on Tuesday morning at 9 o'clock in front of Judge Lutke, having come back from Florida, because that was when I was subpoenaed. The defendants subpoenaed me to testify in a jury trial the day the case starts. I appeared in front of Judge Lutke and I said, Your Honor, would it be possible to excuse myself and Ms. Birch, who had also been subpoenaed by the defendants, until we're needed? And Judge Lutke said, yes, Mr. Watson, you may return to your office. We will call you when we need you. That extended until Tuesday at around lunch.
Is that in the record that's before us?
I think it is, Judge.
That you appeared?
Wait, I don't see, and that's the thing. The judge did no, it isn't, Judge. I apologize. Judge Lutke didn't place that in the record. That wasn't part of the record. But it goes back to Your Honor's question.
The purpose of my question was, if you were subpoenaed, did you appear in honor of the subpoena?
I did.
And then I wanted to follow up to make sure that it's in the record, but now you're not sure that it is.
No, it's not in the record. I know it's not. I know the judge didn't put the appearance on the record.
Okay.
I would never appear in the record because I was never called. And that's what makes it tricky. But go back to your question, why didn't I include all these transcripts? Another candor to the tribunal. Your Honor asked, cost. What about the cost? There was a transcript. The defendants had requested a transcript of a 5-year-old hearing that was used at the trial. That was cost. There was my $12. That was cost. They didn't ask for cost. Judgment was rendered pursuant to Supreme Court rule. If I may, Your Honor, I have one more minute.
Go ahead and finish up.
Judge Lutke didn't have to get to all that. He looked at the statute. He said KSA 6245 doesn't entitle an officer of a company a fee. That issue was raised to the trial court. Under KSA 6245C, the issuing court must enforce this duty. Once the district court was made aware, once the trial court was made aware that the fee wasn't paid, or the proper fee wasn't paid, the trial court had an independent duty to enforce it. Whether you call it a motion to quash, a motion for, I'd like my fee to be the correct fee, but to deny a witnessed party any remedy short of being held in contempt, which to a lawyer would be offensive, there has to be a remedy. There has to be an appealable process. In the cases we cite in our reply, lays it out. The Ryan case says interlocutory. We won't allow interlocutory because it gives rise to too many appeals. If it's not a final order, we will take it up when there is a final order.
You need to wrap it up, counsel.
There was a final order and we have taken the appeal. Thank you. I apologize, Your Honor.
All right, thank you. Very interesting case. We'll take it under advisement, decision as soon as we can.